you.
I think it's Anusavice, I think.
Susan. Well, I know he's on.
Mr. McGuire, good morning.
Good morning. May it please the Court. My name is Thomas McGuire, and I represent Gary Anusavice in this proceeding.
Anusavice, is that how you say it?
Anusavice. I realize it's a difficult pronunciation. We have three issues presented, reported by Justice Spina. And the first one is whether the Board of Registration in Dentistry has the authority to impose reciprocal discipline based on another state's disciplinary proceeding. And it's Dr. Anusavice's position that they do have such authority under the first paragraph of General Law, Chapter 112, Section 61, which sets out their authority to impose discipline in general. And under that statute, the Board has the authority to impose discipline if they find that the licensee is guilty of deceit, malpractice, gross misconduct, or an offense against the laws of the Commonwealth relating to the profession. Statute is not limited to misconduct which occurs within Massachusetts. It doesn't say anything one way or the other on that. However,
In that respect, it's similar to attorney discipline.
yes, Your Honor.
I mean, the real problem here, as I understand it, is can you take what appeared to be a settlement in the form of a consent order down in Rhode Island and convert it into what the board did here,
Exactly.
which was a full-blown revocation of his licenses. Am I correct on that?
That's exactly
Without a
right.
hearing.
Yes.
You don't question, though, that although, or do you? Although the language in the statute that specifically refers to reciprocal discipline doesn't apply to this board, as opposed to boards under the Office of Professional Licensure, do you say that that means the Dentistry Board doesn't have the authority as a general matter?
No, I don't. I don't go that far.
Okay.
Um,
So you
Just
you
the
recognize-
circumstances of this case, because if you look at the language of the statute, a settlement in Rhode Island, I think it was,
yes, it was.
doesn't meet the statutory requirements of reciprocal discipline.
Well, there aren't statutory.
I mean, not statutory.
There aren't statutory requirements.
regulatory.
But my only qualification on the right of the board is that if they want to impose discipline because of misconduct in another state based on disciplinary proceedings in that state, then they have to follow the rules of issue preclusion, as in any case where a court or a board
But
relies on
what do you say
an
about
out-of-state-
Ramirez in that respect?
Well, the
In
issue...
Ramirez, didn't we say that reciprocal discipline can be imposed based on discipline in a foreign state imposed by consent? And what we said was that limiting the application of reciprocal discipline to those situations where the dentist admits culpability or when misconduct is proven in a foreign jurisdiction would make Massachusetts a safe haven for people who enter into consent decrees without making any admission, and there was no final judgment on the merits there. Wouldn't the exact same thing apply here?
No, I don't believe it would, Your Honor. And
It would mean that although he's entered into a consent decree in Rhode Island and he can't practice there, he can come here and practice here.
The fundamental difference between the Ramirez case and this case is that in Ramirez, as part of the settlement agreement, Dr. Ramirez agreed that the agreement would have the same effect as a final.
I know, that's why I'm saying, I said take this language, because I know there's a slight difference in the facts, because in Ramirez, the dentist did not agree with, in Ramirez, the doctor did agree that the allegations should be deemed true, and it should be the same as if they were proven, and the dentist here did not. But take that sentence that we stated in Ramirez, and isn't that just as true in this case?
It is true, but if you extend it to consent agreements, settlement agreements, where there's not only no admission or no finding, but also no agreement that it's a final adjudication, then you're allowing the Massachusetts board to revoke a license based on unproven allegations.
Wait a sec, though. I mean, I think you've got to draw a distinction between the power to discipline and then what that discipline is. At least I think that those may be different. And it was, if Rhode Island says, as it does on its, at least on its website, it lists this as a form of discipline, why is it that Massachusetts can't treat it as a form of discipline in Rhode Island and use it reciprocally for some purpose?
Because I don't think there was record evidence that the Rhode Island Board considered it to be an adjudication
Well,
of
they
merits.
listed on their website as, let's see.
As a voluntary surrender.
Well,
yes.
but they say this website is all the matters of discipline since 1991, and it's right there.
And they reported it to national databases.
Yes, but they also declined to refer to it. They retracted the statement that it was discipline. They initially, the board's administrator initially filed an affidavit saying this is discipline, and then retracted that statement.
All right, but so at best you've got conflict in the state. You've got it listed as one thing in the website, and you've got a retracted affidavit in another. But the fact is he can't practice in Rhode Island for 18 months, and he has to be on probation for 18 more months. I mean, it's hard for me to see that that isn't some form of discipline.
Well, it's, I guess it depends on how you define discipline. Dr. Anusavice was faced with a situation where he was being vilified in the press and didn't want to continue to practice in Rhode Island. And so he reached an accommodation where there would be no finding against him, no admission that he did anything wrong, and no agreement that the consent order would operate as a final adjudication.
Did he do that, excuse me for interrupting, Mr.
Sure.
McGuire, with the expectation, I mean, because it's a little unusual to have, saying this is not a final judgment, the expectation that it would therefore not trigger the reciprocal discipline?
Absolutely, Your Honor,
Okay.
and he filed an affidavit explaining that.
Right.
The Massachusetts proceeding was going on at the same time. It actually preceded the Rhode Island proceeding.
Could he not have inquired then of the Massachusetts authorities as to what the effect would be if he entered into such an agreement?
Yes, and had I known he was about to do that, I certainly would have inquired. I did not negotiate, I did not represent him in Rhode Island. He had Rhode Island counsel for that. And certainly, it would have been wiser to determine ahead of time before he signed the document. But-
Also, another question, in Ramirez, although, as you indicate, the facts were different in Ramirez, the dentist admitted to the truth of the allegations. The cases that were cited in the Ramirez decision are ones that did not involve consent decrees. So the cases that there were several cases that we cited in the Ramirez decision, and in those cases, the doctor did not, the doctor's consent, or whatever it was in the cases, did not include admitting the allegations of misconduct.
Yes, there were 6 cases, 6 foreign cases cited in Ramirez. And in three of them, that's the case. And the difference is that under the statutes of those states, the mere fact of discipline in a foreign state supported or was grounds for discipline domestically.
And why shouldn't that be so? Why do you say that's not so here?
Just as it's not so in the remaining cases cited in Ramirez, because under the statute here, the board's authority is limited to where they find actual misconduct, not merely the imposition of discipline. So the question to be proved, the fact to be proved, is the misconduct in the foreign proceeding. The consent agreement or the finding or whatever dispositional document it is evidence of that misconduct. But if you're going to prove, if you need to prove actual misconduct, the wrongdoing, then you need either a finding, an admission, or an agreement where the parties agree that it will have the effect, that it will operate as a final adjudication.
Okay.
Otherwise, you simply have unproved allegations.
Actual misconduct or actually litigated to establish misconduct?
Actually litigated.
Well, no, because you would say
Sorry.
Ramirez, he doesn't admit or deny, but he says this can, going forward, you would say Ramirez did enough to warrant discipline in this state. wouldn't
That's
you?
right. And that's what the restatement of judgment says, Section 27, that those are the three ways you can establish misconduct: a formal finding of wrongdoing, an admission of wrongdoing, or an agreement between the parties where they acknowledge that it will operate.
What
as a
about
finding.
an implicit finding? In other words, you've done this, you can't practice for 18 months. You agree you won't practice for 18 months. Isn't that implicit that there was some kind of misbehavior or misconduct?
I don't think so, Your Honor. A licensee can surrender a license at any point. He can do it, or she can do it, even though he firmly believes in his innocence of the charge. And there are many reasons for doing that, such as what Dr. Anusavice said is, I'm being vilified in the press. Even if I win this case, it's not going to do me any good. So I'm not going to practice here anyway. All you want me to do is not to practice for 18 months? Fine. But I'm not saying I'm guilty, and I don't think you should infer wrongdoing based on something like that, unless there's an admission, a finding, or an agreement that it will operate as a final adjudication.
Why did he not testify before this board, that is the Massachusetts board?
That was his personal decision based on his feelings about the way he would be treated, and particularly his reluctance to have the press question him, be in public, after his prior experience.
At some point, I think I read this in the decision of the board, the argument that you made, maybe it was in the alternative, was that it might be appropriate to discipline the same way Rhode Island did. That is, a suspension for 18 months. Is that, do I have that right?
Yes.
So you would say that might be all right, even given what he, given this consent order in Rhode Island?
We would have been happy to take that as a disposition. The argument I was making is the Massachusetts board did not have before it the facts of what actually occurred, how serious the offenses were. I made the argument, but you do have, the Rhode Island board did, and the Rhode Island board accepted, was happy with the voluntary surrender. And in fact, the consent order doesn't even refer to it as discipline. It says if you violate this agreement, then we'll impose discipline. And that was satisfactory to the Rhode Island board. And my argument was, if it's good enough for them, gee, something like that ought to be good enough in Massachusetts, because they know how serious it was, and you don't.
So if I know this isn't your main argument, but is one of the arguments that you're making that a substantial problem here isn't so much the idea of using the consent order as for discipline purposes generally, but how it got used? That is, accepting as fact the allegations that are listed in the consent order that are simply allegations, and a lot of other things, and then using that as the basis to revoke Dr. Anusavice's Massachusetts license.
Yes. Anytime you're going to interpret an agreement of some kind, it depends on what the parties intended by that agreement. And in this case, the evidence did not show that they intended it to be a resolution, that they intended it to decide whether the allegations were true.
Right.
And
But that's how the Massachusetts board used it.
that's how they used it, and that's what I'm saying is wrong. There's no problem using a consent agreement or any other settlement agreement, so long as the parties intended it to be a statement as to whether the allegations were true or not.
Did Dr. Anusavice actually offer to enter into the same kind of consent decree as was entered into down in Rhode Island?
Yes, I think I said that during the sanctions hearing, which in the transcript is in the appendix.
Thank you,
Thank
Mr.
you.
McGuire. Ms. Shin?
May it please the Court, Assistant Attorney General Soo-Kyung Shin on behalf of the Board of Registration and Dentistry. This case falls squarely within this Court's holding in Ramirez, which authorizes a licensure board to impose reciprocal discipline based on discipline that was imposed by consent in the foreign
But it
state.
does have a lot of differences, doesn't it? I mean, just the difference in the sense that in Ramirez, as Justice Cowan just read, I mean, the doctor agreed that although he was not admitting or denying the allegations, it could be treated as though they were established, or I don't remember the exact language, but and going forward it could be used for that purpose, whereas here that is not the case at all.
That's true, Your Honor, and I would say that the differences in the language do not matter. This Court's decision in Ramirez did not hinge on any specific language that was contained in the consent order.
Cited those facts.
I'm sorry?
It certainly cited.
That's true, but the out-of-state cases that the Court relied on did not involve the same language that was contained in the
It was pretty
consent order.
strong language in Ramirez. The order would have the same effect as if proven and ordered after a full hearing. That's pretty strong language. Right?
It is, Your Honor, but the underlying basis for this Court's decision was were reasons of public policy, basically to prevent this state from becoming a safe haven for incompetent practitioners. And this policy would be eviscerated if, as Anusavice suggests, the licensee could circumvent Ramirez through basically clever drafting.
Well, the underpinning of where we cited all of those out-of-state cases was where discipline has been imposed. Now, I understand that, you know, you look at whether suspension and so on constitute discipline, but let's assume that, let's give full credit to Mr. McGuire's basis for the claim, which his client wanted to terminate the proceedings in Rhode Island, and Rhode Island said, we're not going to do that unless you agree to certain things. And so he attempts to structure it in a way that he can end the proceedings in Rhode Island, but be free to defend himself if necessary in another jurisdiction where he might want to practice medicine. Doesn't that rather put somebody in a catch-22 position?
I don't think so, Your Honor, and I think it would impose an unreasonable burden on this board to kind of delve into the subjective reasons behind why a party did enter into the consent order in the foreign state. And if you adopt Anusavice's rationale, then a licensee who's facing very serious charges in a foreign state could simply agree to surrender his license forever. And so long as he doesn't put the Ramirez language in the agreement, he'd be allowed to continue practicing here.
Well, there is the other, I mean, there's another party to the proceeding in the other state. That is the other state. They may not agree to that.
That might be true, Your Honor, but I would suggest in that hypothetical, the foreign state would have every incentive to get the agreement done if the licensee is agreeing to basically surrender.
Let me ask you this. Assume that we agree that, yes, you certainly, that is, the board certainly has the right to impose reciprocal discipline, and I don't think Dr. Anusavice disagrees with that. And let's assume that this particular consent order gives some basis for disciplinary action in this state, even in its limited form. Isn't there a problem with the way that the board used it in this case? Because it took as fact what was simply stated in the consent order as, this is what we allege. Didn't say, we find this. Just said, it says, we find that we allege X, Y, and Z. So, and then the board, this board, the Massachusetts board, converts that into these things are true, and then uses that as the basis for discipline. Doesn't that cause a problem?
I'm not sure I agree with that characterization, Your Honor. The rule that this board follows, and that was applied in this case, is the exact same rule that the Board of Medicine, that was at issue in Ramirez.
Except that it's the medicine board's regulation and not this board.
That's true, but this board has adopted that policy through adjudication. It's clearly stated in its prior precedent, and it considers the mere fact of foreign discipline to be enough for reciprocal discipline, so long as the alleged grounds would also support disciplinary action in Massachusetts.
Well, you can still proceed, or the board can still proceed with reciprocal discipline. I don't think Dr. Anusavice is suggesting otherwise. It's the manner in which the Commonwealth of Massachusetts or the board is trying to prove its case, which is by collateral estoppel, is, the presentation of the piece of paper from Rhode Island by the prosecutor before the board, and then sitting down. I mean, you can still bring in the witnesses and have them testify as to what Anusavice did down in Rhode Island, and you can impose reciprocal discipline. I understood his complaint here, or his grievance here, is that it should not be done by collateral estoppel, by applying principles of collateral estoppel, and that's all he's saying.
Well, I don't think this case implicates collateral estoppel because the board considers the mere fact of the discipline to be enough. And as this court stated in Ramirez, when discipline has been imposed in a foreign state, whether after a contested proceeding or by consent, the reciprocating state does not have to be burdened with investigating and proving the underlying basis for the foreign state's action.
Yes, but that's where the language in Ramirez really makes a difference, because Dr. Ramirez, in effect, allowed those facts to be used.
Well, I don't think so, Your Honor, because the out-of-state cases that were relied on by this court did not involve that language, and the underlying basis for this court's decision, Ramirez, was not based on principles of issue preclusion, but on the public policy concerns, basically, to create a safe...
I mean, I know we cite to other jurisdictions for saying where discipline has been imposed by consent, where discipline has been imposed by consent, other courts have held that illicit case need not be burdened. But then right after that, we go on to say by signing the consent order, Ramirez did this. In short, he voluntarily placed himself in the same position as the physician against whom findings have been made. I mean, we go on at length. He doesn't challenge the authenticity or validity of the consent order, nor does he contend that he was denied notice for the right to a hearing. I mean, what we had in the Ramirez cases, it's okay there, it's okay here. You may be correct. You may be correct. I mean, the board said, in I think it was on the rehearing, that the nature of the negotiations between the dentist and the Rhode Island board and the manner in which they reached an agreement on the consent order are irrelevant to the board's determination in this matter and represent an issue not appropriately before this board. In other words, all I look at is, have you been disciplined? If you've been disciplined, that's it.
Right.
Correct?
Correct.
But if you've been, I guess the problem I'm having is if you've been disciplined, that's it. But but if the board, as it did here, goes on and says, and these are all the facts that are true. He did this, he did that, he did the other thing, and it's referring to Rhode Island. Well, that's not what the Rhode Island consent decree says, and I've got one more question in that regard. The board allowed, as I saw it, the prosecuting attorney's motion to dismiss the claim based on the plea of guilty to the tax fraud, right?
Right.
Excuse me?
I think that's right, yes.
But throughout its final order, that's one of the bases on which it finds revocation to be important. It refers to it 3 or 4 times.
I think it was referred to as an aggravating circumstance.
Well, but it had dismissed the claim. That's A. And B, the tax fraud occurred in, the latest date was 93, which is before they did any discipline at all.
That's true, Your Honor, but I think the principal basis for the revocation was the Rhode Island consent order, and Your Honor had asked the question earlier about whether the board here should have imposed the same discipline as was imposed in Rhode Island, and I would say no, because the facts here are different in that at the time the Rhode Island consent order was entered, Dr. Anusavice was already on probation here because he had entered into a 1997 consent agreement with this board in which he agreed to surrender his license for 5 years and then submit to 5 years of probation after that. And he was still on probation at the time the Rhode Island consent order was entered. So I think the facts here are different.
Did the board accept any affidavits at all for the hearing, at the hearing?
I don't think the prosecuting counsel offered any affidavits, and the board did not accept Dr.
Yeah, I know
Anusavice's.
Does the board have regulations that establish a procedure for adjudicatory hearings?
I believe it does.
Yeah.
In an adjudicatory hearing, evidence has to be presented in order to discipline somebody, I take it. And that would include reciprocal discipline cases.
Usually, yes.
So what was the, if you're not applying principles of collateral estoppel, what's the evidence that this man did anything wrong?
The mere, as was the case in Ramirez, the mere fact that he was disciplined in Rhode Island. And there is no question that he was. This consent order on its face requires that he surrender his license for 18 months and then submit to 18 months probation. And under the board's regulations, those kinds of restrictions constitute a disciplinary action, and the consent order was reported to the national databanks.
What regulations of the board?
It's 234 CMR 2.01 defines a disciplinary action to include revocation, suspension, probation, restriction, or denial, restriction of privileges.
Would you give me that site again?
Sure. It's 234 CMR section 2.01 parens 11 parens 1.
Ms. Shin, if we look carefully at the record, which we will, could we conclude that, one, all that the board looked at was the fact of discipline? We agree with the board that what happened in Rhode Island was discipline. Two, that the discipline imposed in Massachusetts was a combination of the discipline imposed in Rhode Island together with the fact that he was on probation in Massachusetts.
Correct.
So all the other stuff about he did this, he did that, is we could strip that away?
I believe it's relevant to the extent that the grounds for the foreign state's discipline does have to support disciplinary action in Massachusetts. So if he was disciplined for some reason in Rhode Island that wouldn't constitute unprofessional conduct here, then the board probably wouldn't have imposed reciprocal discipline, but he does not contest that the grounds for the Rhode Island consent order would support disciplinary action here in Massachusetts, whether under the statutes or under the consent agreement that he entered into with this board in 1997. I have nothing further, so unless Your Honors have further questions.
Thank you, Ms. Shin.
Thank you.